All right. Well, creating a will might seem like something only the elderly or wealthy to think about, but attorney at law of estate planning Natasha Rickards Baugh explains how planning ahead not only secures your legacy, but also ensures that your loved ones are protected and your wishes are honored when you are no longer here with us. Morning, my darling. How you do?
Good morning.
Welcome,
Thanks
welcome.
for having me.
Okay, we were just saying a while ago that the culture sometimes says that if you make a will, you're probably going to transition very soon after that, though.
Yes, I've heard that many times, and I'm here to tell everybody that I've done hundreds of wills, and nobody has died after they signed their will. Not immediately after. Years after, maybe, but not immediately after, so you don't have to worry too much.
Okay, good. That's good to know.
Can I ask you something which kind of moves away from what we're talking about? So she's my daughter, my only daughter.
Right.
And I don't make a will. I have $100,000 in the bank and I die. Why it don't automatically go to her?
Okay, so if you don't make a will, what happens is that your estate, you'd be considered to be dead by intestacy. So there's the laws of intestacy, and the administrator general is the person who is in charge of the estates where the person died without leaving a will.
Right.
Now, if you have a minor, there's no lawyer that can help you to administer that estate. That falls under the direct purview of the administrator general. If she's an adult, then what could happen is that there's a list of relatives and there's an order of priority that those relatives could apply. So at the top, for example, your spouse. Your spouse is the primary applicant that can apply for a grant of administration in your estate and essentially step into your shoes and conduct your affairs. If there's no spouse, then it automatically goes to the children as having priority to take out that application. In instances where the law also goes as far as telling you who gets what if you have no will. So the spouse, for example, would be getting 50% of the real estate. If they're children, they have to share the other 50%. And that's sometimes not what you want to happen. So having a will is crucial to ensure that your wishes are honored.
No, I understand that. I just want to be clear about what you said. So
Right.
if I don't have a will, my family still can get some
Correct.
stuff.
Your family.
But it might take a little
But it's a
business.
particular order. And so your cousins that you would probably want to leave something to may not fall in that category of family members that would benefit from your estate.
Okay.
So
For the purpose of clarity, when you say spouse, that means it's somebody I would have gotten married to, or does it also serve for common law relationships as well?
right. So our law has evolved over the years, and it does recognize common law relationships. Normally you have to get a court order confirming that indeed you are a common law spouse. And it's absolutely essential that when you determine that you're a spouse, that person must be single. So you can't be married, divorced, not really with your wife or husband, have a current partner, and that partner claims common law spouse because technically you're married.
There's a specific time to say common law. In other words,
Right.
and I live for 2 weeks, she's common law. or-
No, 5 years.
5 years.
Yes.
Wow.
5 years.
Okay.
So, all right, so what's the official way to do a will? So I can't just sit down and say, well, I'm Neville Bell, and when I pass, give all my money to so-and-so, and I just put it in my safe, and when I let somebody say,
Okay, no, Jamaica. Can't do that. So, or we have laws that govern validity of a will. So there are certain formalities that must be met in order for your will to be valid. So it has to be executed properly by the testator, that's the person who is making the will. You must have 2 witnesses present at the same time that sees the testator, sign the will, and witnesses their signature.
does one have to be a
Testator.
lawyer?
Valid.
Yeah.
One have to be a
Who's
lawyer?
that?
No, the testator is the person making the will.
Got
So
it, okay.
if I'm making the will, I'm considered to be the testator. So there are certain formalities that must
Sorry,
be
I
made.
jumped in at the wrong time. You said you got to
2 witnesses.
Okay, yeah.
So you must have 2 witnesses present at the same time.
Okay.
And it's highly recommended that those witnesses are not beneficiaries in your will.
Okay.
Right? So independent persons, just for transparency and clarity, the law is designed that way. You can have instances now, the law has been changed, where a witness is a beneficiary, but you have to go through a court process for the court to analyze that situation and determine whether or not it's proper.
Okay.
It's proper.
Right.
So what could actually be improper about that?
Well, there are situations where there is, collusion or there's
like
some
somebody
doubt
forcing your
because
hand.
somebody's
Got
saying
it.
that I was
Okay.
a witness but actually didn't witness it. So we try to prevent it so the persons that are witnessing are independent to the whole process. Also, that the persons witnessing these signatures, they don't necessarily have to read your will. They just
Needs to sign.
sign and sign to the fact that they have seen you, the testator, the person making a will, sign off on their will.
Let me ask you this about the changes. How many times and can I actually change my will? Am I able to do so?
Absolutely. And so your will is one of those as your life changes, circumstances changes, you acquire more assets, you want to change out beneficiaries, you can amend your will. And you amend it formally by a codicil, which is a secondary document, or you can just simply tear up that old will, redo another will, and it's your last will that is what the court would take into consideration when administering your estate.
And when I change my will or update it, do I have to have different, what do you call them, people around?
Witnesses?
Yeah.
Or I can use
Yes, you need to witness the updated
I know, but I
codicil.
can use the same people.
Yes, absolutely.
So I can make the will and I leave everything to her, and then me and her fall out. And I say, say me not
You
get-
tear up that will, you make a new will, you follow the formalities that we've just discussed, and you're good to go.
If I don't have the will now, all right, and I don't have spouse nor kids, want to my money or want to my assets.
If you don't have a will, don't have any spouse, kids, then again, there are other categories of relatives that can benefit. Grandparents, siblings, aunts and uncles, and if you have none of those relatives, then the government will ultimately
And I can give my will, I can give my assets to charity. I don't have to give it to family. But
Absolutely.
I can just say I leave all my money to the Cancer Society.
Absolutely.
I can do that.
Absolutely.
Oh.
Your will is your direction, your wishes, and so you can do whatever it is that you want with your will.
I know we don't have a lot, and you said you've done, but where are we? I don't know, I mean, you probably can't speak for the country, but where are we?
So I've been practicing for about 13 years, and I think in recent years there's a more desire to do estate planning. Wills, powers of attorneys, trusts, all those things. People want to consultancy because they see how it's beneficial, how it can help, and especially with dependents, it's absolutely
What's the
important.
youngest person you've seen write a will?
Maybe 22.
22.
Nice.
Yeah,
Nice.
22.
But let me ask you though, because is a will enough? Does it, cover everything? When they talk about estate planning, is there something else that I should be considering as well?
So the will, I would say, in my opinion, the will is the first preference. Like, you must have a will regardless of any other estate planning tool that you may want to utilize.
Okay.
So there are various tools that you may want to utilize. If you think about estate planning, you could utilize a power of attorney, which would have situations where you're alive but can't make certain decisions or do certain things that you appoint somebody to act in instead. Trusts are another way of securing assets for beneficiaries over a long period if there's a lot of certainty. So there are lots of tools that can be utilized for estate planning, but I do think having a will is always primarily important. It can always substantiate everything that else
I
that
have
you
4 kids, so if I don't leave a will and then find out I have $22 leave in the bank, can the kids come together and say, well, we're not going to fight over that. We're just going to divide up the money and we'll move. That can happen or no?
So if you're the only person on your bank account, they're going to have to get a grant of administration without any will. So they're going to have to go through the administrator general. And are your children adults?
Yeah.
Right. So they're going to have to go through the administrator general and ask them basically if they can take out a grant in your estate. Once that's approved, then they would apply to or Supreme Court to get a grant of administration that would put them in a position to access your bank account funds, gather your assets essentially.
Right.
And then yes, if there is no spouse and only children, then they're to share it equally. That's what the law provides.
So it can happen that way.
It can happen that
Kids
way.
can come together and say, we're not going to fight over this. It's only $22, you take 5, me take 5. That can happen.
Right. But again, having a will is essential. You don't want to die without it because then they could just start the process immediately. And one of the most important things is that with a will, you get your power, the executor, the persons that will be acting in your stead, from the will. So not necessarily from the court, which means that I can have a will, the court hasn't given a grant yet, And I can start going to the bank and saying, can you tell me about the assets in his estate? Can I conduct business, safeguard the assets in the meantime? Because you get your power from that document.
Okay.
So it's absolutely important.
Final question for me. I'm looking at it says last will and testament, and it seems like it's a form. Is a form we use, or I can just take a piece of
That's
paper
what I was going to
and
ask
just
her.
write
So,
outside?
so we do have widely available what we like to call the time store book wills, which is a form. People use it as a go-to, but it's not recommended because
It's not recommended.
it's not recommended. It's recommended that you consult an attorney, and it's a document that will be prepared. Because how you write the will is also extremely important. You have to think about things that identify assets clearly, your beneficiaries clearly. We have situations where somebody owns a house and they want to will one room of the house to somebody and the backyard to somebody else, and practically that
can't work.
happen because it's
That
one
actually
property.
happens?
All the time. I just looked on a will yesterday, and the will says, I give 1 square meter of my property to X, and another square meter of my property to Y, and the dwelling house to Z. So, I mean, it's very difficult to determine from a
just leave my
practical...
bathroom for David.
It won't work.
I decline.
So,
take it at all.
I mean, people, and then you have people that have 30 grandchildren and want to leave a property to 30 of them. That is just problematic, not recommended. They don't describe the assets properly.
Yeah.
You have Paul Jr., you can't differentiate from Paul Sr., so you don't know who the beneficiary is. So there are a lot of things that you have to consider.
How you deal with that when that happens?
With the
when
sometimes you have to get
court.
court's direction. You have to try and use other evidence to determine what exactly the testator, the intention of the testator is. Sometimes it's so bad that the gift is just void for uncertainty. We have no idea.
Very well explained.
Lots of information.
Thanks a
Thank
lot
you
for
so
coming.
much.
All the very
No
best for the year.
problem. Thanks.
Attorney at Law of Estate Planning, Natasha Rickards Baugh.
After the break, guys, reforming Jamaica's adoption system. We'll explore that. Stay with us.
To come.